decided by the WTO panel, and even in cases so far until the Australia plain packaging case, it seems that Articles 7 and 8 have not been given due importance by WTO panel. However, I argue in my thesis and that Articles 7 and 8 should, when you're interpreting Article 13 of TRIPS and whether it allows for broad public interest exceptions in national laws, one should consider Articles 7 and 8 of TRIPS because Article 31 of the Vienna Convention on the Law of Treaties says that a treaty should be interpreted in the light of its object and purpose. And Article 7 and I would say even Article 8 refers to the objectives and principles of the TRIPS agreement. So when you're applying Article 13 of the TRIPS, you need to consider and give adequate importance to Articles 7 and 8. This was also recognized in the Doha Declaration on TRIPS and Public Health. Articles 7 and 8 help national governments to tailor their IP law to meet socio-economic objectives. And it has also been argued by IP scholars that Article 30 should be interpreted from the vantage point of IP users, because some IP scholars like Ruth Okediji has said that Article 13 is a limitation on limitations. So therefore, they have argued for a narrow application of Article 13. I apply Article 13 to the DU photocopy case, and I address the criticism of the WTO panel in US copyright, which adopted a narrow approach towards Article 13, especially with respect to certain special cases. Some of the scholars say that when you talk about the first ingredient of Article 13, it talks about users to be restricted to certain special cases. So when you the interpretation of this element is that the exceptions in national laws should be narrowly defined, rather they should be clearly defined. And I argue that in the educational exception in Indian copyright law has been defined specifically to apply only to uses which are in the course of instruction and by a teacher or a pupil. The second element of Article 13 is that the use should not conflict with the normal exploitation of the work. It is widely acknowledged that under the second ingredient of Article 13, every commercial use of a copyrighted work is not prohibited. The users and the US copyright panel has interpreted this uses which conflict with the normal exploitation of the work as uses which generate significant or tangible revenue. In the DU photocopy case, when Rameshwari was selling course packs to students, it was doing so only at a very nominal rate, and it was not a profit-making venture for them. Further, the course packs cannot be considered a substitute of the books because the publishers sell books to universities and course packs are only for students. The third limb of Article 13 is that the use should not result in an unreasonable prejudice to the legitimate interests. From this we can infer that certain amount of prejudice because of the use of a copyrighted work is considered reasonable. And the question which a court would look into is whether the reproduction of a work prejudices the circulation of the work. If yes, it is an unreasonable prejudice to the legitimate interests. I argue that the audience for course packs and books are different in this case, the course packs being for students and the books being bought by universities. And there's also probably room to argue that the course packs, instead of unreasonably prejudicing the legitimate interests of the author, are in fact promoting the publisher's works, because when a student reads an excerpt in a course pack, he may be interested in reading the entire book, and he can recommend that the university purchases more copies of the books. Even when you apply public interest, the public interest provisions to the DU photocopy case, the case is only strengthened, because the public interest in this case is access to knowledge, which is not a trivial concern for a country like India. Delhi University is a publicly funded university, and my argument is that you cannot monopolize knowledge by requiring students to buy textbooks from the publishers themselves, and therefore universities should be free to disseminate the works, especially since they've already bought those books from the publishers. Universities in the UK, including Oxford University, has encouraged open access publishing by academics. Therefore, this scenario should not be any different for India. I'll quickly come to my last slide. I just want to emphasize that Delhi University students belong to different economic backgrounds, some of them coming from a very poor economic background, and therefore it is imperative that that countries do recognize that access to knowledge, which is broadly in public interest, should be respected, and copyright laws should make adequate provisions for that. Developing countries' behavior has often been likened to Robin Hood for stealing from, it has often been likened to Robin Hood for stealing from the rich to give to the poor. But I leave with the question that when academics conduct research using public funds, and Delhi University is a publicly funded university, and you're already putting that research behind a paywall, because academics have to pay to access articles when they're using them in their research. And then when you're further restricting the dissemination of that knowledge by saying that universities cannot circulate those works to the students, you risk stealing from the poor and giving to the rich. Thank you.
Thank you. Delhi University photocopying case is very interesting because there are wide spectrum of views on the interpretation of the three-step test of the TRIPS. And interestingly, the second speaker will be dealing with a similar issue of private copies in digital age. And the second speaker is Ms. Sujin Lee. She is the International Business Development Director at CJ, which is one of the largest companies in Korea. And she'll be talking about private copy and digital age. Please welcome Sujin Lee.